Catherine Lang-Anderson, welcome to Trade Finance Talks TV.
Hi, good to see you. Thanks so much for having me on.
Such a pleasure, and welcome to ITFA. Here we are in kind of sunny Porto.
In a basement in sort of sunny Porto, living the dream.
We could be anywhere. No, we are in Porto. So tell us, what's your backstory, elevator pitch? Who are you, where are you from, and what do you do?
So I'm Catherine Lang-Anderson. I'm a partner at Allen Overy in the London office. I focus on trade and commodity finance, and I'm global co-head of our trade and commodity finance practice. So within that, I look at all the different structures that we see across the trade finance space, across the commodity finance space, be that receivables finance, inventory financing, structured loan facilities, and anything and everything in between.
Lovely. So possessibility and acceptance, I think they've been the key words this morning. I think we've been really talking about the legal issues around trade documents. How is the landscape changing?
So this is the hot topic at the moment. Everybody wants to move to digitalisation of trade finance. You see that from the number of sort of people heavily involved in the tech world who are here at this event, the conversations that we're having. I think during the pandemic we really struggled, and it really laid bare some of the issues we have with as an industry being so paper-based. So there's really now a massive catalyst to move forward from that, and the tech is there to do so. The problem is the law is not currently set up to properly facilitate that. And that all comes down, as you say, to the question of possession. So this is what we spend a lot of time thinking about as lawyers. And the issue is that all of those documents that we use every day in the world of trade, so be it bills of lading, bills of exchange, promissory notes, warehouse receipts, all of these docs, they actually are almost magical documents with special properties sitting behind them as a matter of law, right? So the rights to require performance under those documents are actually embedded in those pieces of paper. It's much more than a normal contract, which would just be a piece of paper that evidences the contractual agreement the parties have. These kind of trade documents actually have an ability to require performance just based on the rights in that document. And it follows from that if you possess the document, if I give you one of those kind of documents, you might get certain rights that flow from having possession of that document. So say I give you my bill of lading, you might be able to take a pledge over the goods that it represents, just partly because you are in possession of that piece of paper. You might be able to have a lien over that document. You don't need to give it back to me potentially until I've satisfied a debt or whatever else it is. There's all these sorts of rights that are only switched on because you've fallen into the legal concept of having possession of it. Now the problem is, English law and many other laws at the moment don't actually anticipate that intangible assets could be possessed. It's starting to sound a bit like a horror film, isn't it? But they only allow for the concept of tangible assets to be possessed.
Like paper.
Like paper, bags of gold. Anything that's physical, we can see it. Not digital assets in cyberspace that are considered by law to be intangible. And that makes complete sense when you think about it, right? These laws have been developing for hundreds of years. This idea of possession goes back to sort of medieval times. Nobody was thinking when they wrote the Bills of Exchange Act 1882 that we need to consider intangible trade documents held on a technology platform. So it's understandable, but the problem is that certainly in England and Wales, when the courts have come to look at this question and said, well, can't we just kind of extrapolate reasoning from when we look at tangible assets and apply that to digital equivalents, they've said no, that is a step too far for the courts to take. It's way too fundamental. We need to actually go back to statute, and we need to change the law around this by statute.
And that is some of the proposed trade documents acts that you were talking about earlier this morning, and there are significant proposals for reform. Am I right in saying that they're not yet in law? But can you tell us about what the recent developments are and what this could bring to trade?
Yes, so they're not yet in law in England, but I think they will be pretty soon, because the bill is going through Parliament it was in the Queen's speech for the current session. It will be going through Parliament maybe by Christmas or maybe early next year. I asked yesterday if there was an update on that, and we're not sure, but certainly very soon. And the thinking is there's probably not going to be too much opposition to the bill, partly because the Law Commission did such a brilliant job of consulting all different industry players to really do something that was really tailored to what the industry needs, and partly because so much thought has gone into kind of the framing of the bill, how it's drafted, and actually it's actually a very simple, we can maybe talk about that a bit later, but it's actually very simple what it does. So that's going through. We've got so that's the England and Wales perspective. From a sort of broader perspective, there are things like MLTER, MLTER, however you want to pronounce it. That is a model law that UNCITRAL put in 2017. So that provides a framework. So the English solution is very much tries to be compatible with that, but obviously with the specific nuances of English law sort of overlaid. Other countries have adopted that model law. Hopefully, as things progress around the world, everybody will take inspiration from that, the English approach, other countries like Singapore that have done similar things, and really try and get some consistency in how we approach this. Because if we're not consistent, then this isn't going to help us in the sort of international context in which we do business.
Yeah, absolutely. And I guess once this law gets adopted, what does this actually mean for trade? Let's say from a corporate's perspective and also from an FI and bank perspective.
Yeah. So what it means is suddenly we have solved this fundamental, from an English law perspective, we've solved this very fundamental blocker at law. Two parties having the same kind of rights that they would have around trade documents in electronic form as they currently do in paper form. So suddenly all of the amazing developments that have been done sort of in the digital space, suddenly you're overlaying that with actually now we've got these rights at law. So we won't be so focused in the future on trying to contract around the legal issues and finding clever solutions. We'll just be saying, look, we can just do all of this on a platform in the same way as we might have done with paper. So I think that's really exciting for any market players, be it banks, corporates, insurance companies, people who are interested in investing in trade assets. It kind of unlocks all of that great stuff that's been developed over the years. But I think from a corporate perspective, I suppose there is some thinking that it might unlock trade finance for SMEs, because suddenly we're doing more digitally. You're increasing efficiencies, hopefully reducing costs that hopefully gets passed on to SMEs, by the way, and unlocking some of that efficiency that might allow, it might lower barriers to entry. For banks, it's great because suddenly, they can get much better comfort from their lawyers on the legal certainty around the structures they're doing. That's really important. So it's a good news story for everyone. But I think realistically, in the medium term, we shouldn't get too ahead of ourselves, because like I say, although this fixes the issue under English law, there is still a journey that we're on, kind of until we're comfortable globally that these paperless instruments work.
Yeah, well, I guess cautious optimism for the acceptance of those really important trade documents in electronic format under English law, and hopefully some exciting developments.
Yeah, I was going to say maybe a bit more than I'm a lawyer, so I always have to sound a bit cautious, don't I? But
maybe I sound like a lawyer.
But I think actually much more than that, it's really exciting, right? Really exciting, because English law, it's used in 80% of trade finance transactions globally, roughly. So it's hugely important. It's very persuasive for other legal systems. It's really exciting, and also it's just an example of the Law Commission working with the legislators to actually solve a problem that allows people to do business better. So we're not talking about a new law. That's why it was really fun to be able to do the slot today and talk about this law, because it's not a kind of, you know, sometimes the legal slot is a bit of a downer where lawyers tell you about new regs that you have to worry about and comply with. This is actually really exciting because it's just trying to catch the legal system up, maybe even put it a little bit ahead actually of where the market is going.
Yeah, absolutely. Catherine, it's been such a pleasure. Thank you for joining us
Thanks
on
so
Trade
much,
Finance
Deepesh. It's
TV.
really good to speak to you. Thank you.
See you soon.
Enjoy the rest of Porto.